telehealth during the time of COVID-19. So thank you very much, everyone, for joining us. Just basically a running order of what's going to happen today. We are going to be having a talk from two legal experts from Norton Rose. So I must say a very big thank you to Yash and Priyanka Naidoo. Now, I did ask Yash and Priyanka, they are not related in any way, but they are both great lawyers, and they are both from Norton Rose, which is one of R2's legal partners. So Yash and Priyanka, thank you very much for your time today. Yash is an associate in insurance litigation, and he specializes in medical malpractice and HPCSA queries. So he's going to be talking to us a lot on medical malpractice and telehealth. And then we have Priyanka, who is an associate in the technology department of Norton Rose, and she's going to be talking to us about the technology and cyber risk side of telehealth. So I'm sure you're going to hear from a few interesting things from some great experts in this time of telehealth. Then after that, we're going to hear from R2's product head or product champion of MedMal, Fia Samuels. She's going to wrap up with some of R2's approach to medical malpractice during COVID-19. And then we're going to briefly hear from Ryan van der Koolwijk, who you've heard before, but with this advances into telemedicine, Ryan is going to talk to you a little bit about the cyber risks associated with this telehealth. I must say I've had a really interesting morning with both of my children going back to school and learning fully online, and it's been an absolutely amazing experience. And I've got no doubt that the healthcare sector is going through many of the same changes. So it's a really interesting time for our worlds, and I think this coronavirus has really pushed us forward kind of into the future of technology, and I'm not sure that we're always ready for it, but hopefully today will help you and your clients think about some of the risks. But at the same time, let's embrace technology and enjoy these new ways of working, just like today. Before we get started, I'd like to point out the R2 logo, which has been temporarily modified. And really this logo is just to say to all of our team at R2 and to all of our brokers, we've pulled our little man in the logo apart because as a business, we're taking physical and social distancing really seriously. And we recognize the importance of this. So we encourage all of our team, our brokers, our families to practice physical distancing and take this lockdown seriously. But at the same time, we'd like to say to our team and our brokers that R2 is more connected than ever, and we're going to be doing many more events like this to keep in touch with all of you. So thank you very much for listening, and I'd like to hand over to Yash from Norton Rose. He's going to share his presentation. Yash, if you can, and please remember to message me questions, and I will grill the good lawyers as we go. So thank you very much, Yash, and can you share your presentation with us?
Thanks a lot, Justin. Just give me an indication if you can see the presentation.
Yes, we are looking good, and we can see it, and we can hear you. You're looking good today, so let's get going. And over to you. I'm going to mute my mic, but I'll come on if I'm needed.
Thanks a lot. So thanks everyone for joining me on my birthday. I must say it's probably one of the better attended birthday parties I've ever had. So thanks a lot for that, and thanks for the intro, Justin. As mentioned, today we're going to be talking about telehealth during and post COVID-19. Now, I saw that the meeting invite was titled eHealth Goes Viral. And I must say, if you told me that title a few weeks ago, I would have said it's too soon. But I mean, we've been in lockdown forever, so I enjoyed that pun of the eHealth going viral. Anyway, as I said, so today it's going to be myself and my colleague Priyanka. She'll chip in a bit later. So let's get started. Let me go to the next slide. So bear with me. I know that you all are very well aware of this, but there's a reason why I'm starting right at the beginning and talking about the regulators and the acts in terms of which they've been established. It's to try and give everyone an overall picture of where exactly do these bodies get their authority to make things like regulations and directions and things like that. So just to take a step back, we should all realize that, all know that law in our country is passed by Parliament. Parliament makes these things called acts, or commonly known as legislation, but you'll hear of them as acts. And these acts then give powers to the executive, such as the Minister of Health or the professional bodies, to create further laws, which are called regulations, and those are known as subordinate legislation. Now, the Health Professions Council of South Africa is one of these regulatory bodies, and they've been established under the Health Professions Act. And the Allied Health Professions Council of South Africa is another regulatory body, and yes, you guessed it, they've been established under the Allied Health Professions Act. I've listed just a few of the professions which are registered with each of the bodies. So, for example, the Health Professions Council has your doctors, dentists, ophthalmologists, things like that, whereas your Allied Health Professions Councils have your chiropractors and your acupuncturists, etc. So these are the two regulators that I'll broadly be talking about today. Now, specifically on the HPCSA, how do they regulate the professions that are registered under them? So firstly, well, there's two main ways that they do it. Firstly, they publish what are called rules or regulations, and these are published in the Government Gazette. And as I mentioned previously, they're regulations under the Act, so they are technically law, although they have a subordinate hierarchy in our legal structure. And another way that the HPCSA does this is by means of guidelines or booklets, which they publish on their website. And at present, there's 17 of these booklets, and I'll talk about them just now. But these, strictly speaking, are not laws because they haven't been passed in terms of the Act, and they haven't been published in the Government Gazette. So technically they're not laws, except for one, which is the ethical rules, which has also been published as a regulation in the Government Gazette. So I said, let me just give everyone a snapshot of some of the examples of the first type of way that the HPCSA regulates their professions. Now, this is a screenshot. It's literally a snapshot from one of the databases where us attorneys can go and look at all the regulations that have been passed underneath or below a specific act. So this is a list of the regulations that have been passed under the Health Professions Act. And if you'll see that it's a small snapshot, because if you look at the right of the slide, you'll see that scrolling bar. I'm not sure if you can see my mouse, but the scrolling bar is pretty high up, which would indicate to you that there's a ton more below this, and that's exactly the case. There are tons of these regulations that have been passed either by the Health Professions Council or the Minister of Health in consultation with the Council or separately. And I said, let me just take a snapshot of this particular portion because it gives a good overview of what exactly the types of rules and regulations are promulgated in the Gazette. So if you look near the bottom, for example, I'll move my mouse there in case you can see it, but these are the regulations defining the scope of the profession of optometry and dispensing opticians. So this is a regulation which sets out what's the scope of practice for an optometrist, for example. Another good example in this snapshot is around the top here where my mouse is, which is the ethical rules of conduct for practitioners registered under the Health Professions Act. So you'll remember earlier I mentioned that the HPCSA has booklets, but not all of them are actually law. This one is. It is a booklet and it's been published in the Gazette. So technically speaking, it's part of legislation. And then the second example that I gave you was of how the council regulates its professions is by means of guideline booklets. And this is, again, a snapshot from the HPCSA's website this time, where you can find these booklets. Now, I must point out that it's not that easy to find these booklets, and I wish it was a bit more user-friendly, the HPCSA's website. If you look at the top tab, you'll see publications, legal affairs, etc. Now, a reasonable person would probably think that you'd find these booklets under publications or legal and regulatory affairs, maybe even professional boards. No, actually, you click on core operations, then you've got to click on professional practice, and then you've got to click somewhere else on the left-hand side, and eventually it takes you to these booklets. I wish it was a bit more intuitive, but just so you know, these booklets are there and you can find them if you look hard enough. And further examples are on the screenshot of the booklet. So you've got the general ethical guidelines, which is booklet 1. There's booklet 4, which is seeking patients' informed consent. And the booklet I'm going to be talking about a bit later is the one on telemedicine. So going back now, I've given you the broad overview of how the law works on these things, but going back to telehealth, which is what we're here for today, what is the position of these two bodies on telehealth as it stands? Well, you'll see at the top of the slide, I've put there 2020 BC. That stands for 2020 before coronavirus or COVID-19, which is essentially just over a month ago. So it's very recent. And this is the position that both of these bodies held just over a month ago, 2020 BC. The Health Professions Council's position was contained in their booklet 10, which I just talked about. And I'm not going to read that whole sentence out there. You can read it in your own time. But essentially, what the HPCSA envisaged telemedicine to entail was a situation where you have two healthcare practitioners, one situated in a rural area, the other in an urban area as a specialist. And a patient would go to the doctor in the rural area, for example. It doesn't necessarily have to be a rural area, but it just needs to be an area where there's no access to specialists. So the patient goes to that doctor is called the consulting doctor. That consulting doctor will then refer via telemedicine to a specialist because the patient in the area of the rural area, for argument's sake, can't access that doctor in the urban area. So it was a very specific situation that was contemplated by the Health Professions Council 2020 BC. Now, the Allied Health Professions Council, on the other hand, had published one of these notices in 2011, notices that I talked about previously in the Government Gazette. So it was, in effect, law. And they defined telemedicine as the exchange of information on healthcare at a distance by whatever means, whether privately or publicly, for the purpose of diagnosis and treatment of any persons. And I like that definition because it's simple, it's not a long story, and it encompasses virtually everything you can think of that would entail telemedicine. But 2020 BC, the Allied Health Professions Council's notice said that the practice of telemedicine, in their view, is unprofessional conduct. So that was their stance on it just over a month ago. But then what happened, as we all know, life has changed over the past few weeks. COVID-19 has come about. There's been a lockdown, and to their credit, both the regulators have relatively quickly tried to adapt to the present situation. What did the HPCSA do? So on the 26th of March, they put out a guidance note to their practitioners via email and also on their website. And they said that there's certain changes that they're implementing to their booklet 10 guidance note. And what they said was that telemedicine, which was the word that was used in the original booklet, is hereby replaced by telehealth and includes, among others, telemedicine, telepsychology, telepsychiatry, etc. And then the important part is underlined. It says involves remote consultation with patients using telephonic or virtual platforms of consultation. So the whole story of two practitioners in different areas and a consulting practitioner and a servicing practitioner seems to have gone away for this period. And another point that they mentioned was that practitioners may charge a fee for services rendered through a telehealth platform. So now you can imagine lots of practitioners' eyes started to open up to this. And then they read the next point, which is where I've put the big but in, which says that only allowed where there's an established patient relationship, except in telepsychology or telepsychiatry. Now, it's been reported that following this guidance note, a number of professional organizations gave a bit of feedback to the HPCSA, to put it mildly. It's reported that there was some backlash to say that what's the point of amending these guidelines in COVID-19? You know, the whole purpose of telemedicine in the present situation that we're having is to encourage things like social distancing, flattening the curve, avoiding having to inundate our healthcare facilities with patients that are just coming for general screening, you know, a little sniffle here or there. So what is the point if you're going to restrict this strictly to doctors who have a relationship with the patients? And following that feedback, about a week later, a further guidance note was put out by the HPCSA. Surprise, surprise. And in this guidance note, what they said was that it should be preferably practiced in circumstances where there's already an established patient relationship. But where such a relationship doesn't exist, practitioners may still consult using telehealth, and provided such consultations are in the best interests of the patients. And then regarding the point on charging, they said although practitioners may charge, they're cautioned against over-servicing and perverse incentives. So a bit of a change on the original guidance note. Now it's acceptable to consult with new patients, provided that those consultations are in the patient's best interests. Then going back, what did the AHPCSA do? Now on the 25th of March, they put out something, and I liked the title that they gave it. They've called it the Extraordinary AHPCSA Policy Decision on Telehealth and Telemedicine. And they were more specific, and they said all practitioners and therapists may practice telehealth for the period of the state of disaster, and any previous board notice dealing with telemedicine is suspended for the duration of the period that South Africa has declared a state of disaster. So you'll remember I mentioned the previous board notice 2020 BC that the AHPCSA put out saying that telemedicine is unprofessional conduct. Well, this extraordinary policy decision says that that's suspended for the period of the COVID-19 lockdown. And then a day later, there was another EXCO directive by the AHPCSA saying that you should only receive patients in your practice in emergency cases only, and otherwise use telehealth or telemedicine. And because there's so many changes happening as the days go on, I just checked the website recently and I see just a few days ago on the 29th of April, the AHPCSA has now put out another directive saying that from 1 May, all practitioners can see patients at their practice, but still they're advising their practitioners to rather make use of telehealth and telemedicine according to their guidelines. So I like to do these snapshots where this is now showing the position in present time, so it's not 2020 BC anymore. And just to show you what I think has changed in essence, I've struck out the old provisions and just left in the applicable ones. So for the HPCSA, that's the Health Professions Council, essentially telehealth is remote consultation with patients using telephonic or virtual platforms. And the Allied Health Professions Council, that definition still stands, except that now it's no longer unprofessional conduct. So why the change? Of course, we all know this, and I've touched on it a bit earlier. It's to help prioritize patients and to ensure there's social distancing, flattening the curve. Another great upside of or remote consultations is that you don't need to wear a mask. You don't need to sterilize your rooms afterwards or do a deep clean. So it's saving important and crucial PPE that could be used in our hospitals where they're quite lacking, especially in public institutions. So that's the reason why this has happened. These developments have happened, and we must always bear that in mind, the context of why these changes have come about, because it's useful to instruct us or give us an insight into how the regulators were thinking and why they exactly came out with these changes. It's not like all of a sudden they woke up one day and said, well, telehealth is a brilliant thing, let's do it. Let's change our position all of a sudden. This is the context behind why they've made these changes, which is very important. So what exactly does it entail? As I said earlier, the HPCSA just simply says telephonic consultations or virtual platform consultations. Now, initially in the guidance booklet, I mentioned the whole complex structure that was envisaged. And one of the guidelines that were in the original booklet, which still stands, by the way, the booklet that is that there should try and be a video link between the two parties, and it should try and replicate face-to-face consultations as much as possible. Now with this new guidance note, the fact that they use the word telephonic consultations would tend to indicate that that's no longer the case for present purposes, but that's as much as the HPCSA has said. You can sum it up in 2 bullet points. The Allied Health Professions Council, on the other hand, were, to their credit, in my view, very specific, and and have given detailed guidelines which they've published and you can access. The link will come up later. I've just put up a few of the requirements which I thought were interesting, just to give an example. So firstly, they say it must be a two-way video link up, and the practitioner must be able to see the patient on their screen and hear their voice. They say it must be recorded and the software must be secured from end to end. They even go as far as saying you can't use any internet connection that's slower than a 3 meg line, and you must be professionally dressed. And there's other detailed guidelines which you can find in the note, and I'll put up the link later. So they've been much more precise in what they prescribe their practitioners should do regarding remote consultations or telehealth. Who can do it? As the HPCSA, the Allied Health Professions Council's directive has said, all practitioners, subject to following their guidelines and also subject to doing it within their scope of practice. The HPCSA, they haven't said exactly it's for all practitioners, but for all intents and purposes, we can assume that that's the case. Now, who would it be suited to? In my view, I'd say certainly GPs who, in the ordinary course of things, get a waiting room full of people that come in for things like a cough or a sneeze and other related things that could possibly be dealt with via telehealth. But what about specialists? Can your gynae or your obstetrician or your surgeon make use of telehealth? It's an interesting question, and I thought it's a good point of the discussion to get into another development, which is sort of related, that the HPCSA has come up with in recent times. And it's regarding specialists and the practice of specialists. And it's caused a lot of confusion, which hasn't really been cleared up. But again, I go back to 2020 BC, just over a month ago. And a lot of specialists might know that this is the case, this is the law, but they might not know where the actual authority comes from. But the HPCSA has a regulation called, and remember, this is a regulation that's been published in the Gazette, so it is law, it's not simply one of their guideline booklets. They published a regulation called the Regulations Relating to Specialities and Subspecialities. And one of the important provisions of that regulation says that specialists must confine their practice to their speciality or related subspeciality. So an obstetrician must do obstetrics and confine their practice to that. Ophthalmologists similarly don't stray out into the realm of, for example, a general practitioner. Don't go and open a GP practice and on the side catch babies as an obstetrician. However, and then there's also ethical rules, which is one of the rules in those booklets and also has been published. And it says that a practitioner must perform, except in an emergency, only a professional act for which she or he is adequately educated, trained, and sufficiently experienced, and under appropriate conditions and appropriate surroundings. But with the COVID-19 pandemic, another note was put out by the Health Professions Council, and this time they didn't email this note to their practitioners, which was what caused a bit of confusion, but they did put it out on their website, and it is accessible on their website, albeit at also in a hard to find place. You have to do a bit of clicking around, and I can show you where it is if you need to find it. But they said that they understand that the state of national disaster is an emergency which requires practitioners to meet the challenges that comes with it. And they've said that specifically regarding the Ethical Rule 21, which I just spoke of, the HPCSA considers the current state of disaster as an emergency for the application of this rule. And importantly, I should have highlighted it, but I didn't. It says whenever practitioners are called on to perform professional acts which are outside the scope. So it's when they're called on, then consideration should be made by individual practitioners as to their ability to perform such professional acts with reasonable skill. So impliedly, what the council is saying is that if you've been asked to practice outside of your scope, you probably can do it, with the caveat that you must make sure that you're reasonably skilled and you can do it in a reasonably safe way based on your training and experience. That's the first point. The second point regarding specialists is that, as you can see, I've highlighted there, medical practitioners and dentists who hold registration as specialists in terms of the Act are allowed not to confine their practice to the speciality or subspeciality or related specialities in which they're registered for. So this note says that, the specialists can, if need be, practice outside of their scope. This slide sums it up. They can practice outside their scope, provided it is done with reasonable skill and care and taking into account their education, training, and experience. Now, please take this slide as a bit of a sensationalist slide, because I'm by no means saying that specialists must now go and open up a GP practice and start consulting by telehealth. Again, I remind everyone that we need to take into account the context behind why these changes were made, and it is the COVID-19 pandemic. And I think a perfect example of where it is applicable and where it probably is acceptable is in the case of, I'll use my sister as a specific example. She's a registrar in surgery at one of these academic hospitals, so she's specializing to become a surgeon. And all they do every day is cut and stitch, and they don't do any GP work or any internal medicine work, for example. But their hospital has recently told them, all the surgeons, that you're going to need to every now and then present yourself at the trauma department to do screening of patients. Now that's, technically speaking, outside of their scope, but they've been called upon to do it. So the council would probably not frown upon that. Now, I need to quickly, I can see I'm looking at my watch and Priyanka's WhatsApping me and reminding me that the time is going. So let me just breeze over this quickly. There are risks involved with telehealth: misdiagnosis, breach of privacy, patient complaints. Those first three bullets, though, if you think about it, these are risks that are inherent even in face-to-face consultations. So even though I say that these are risks inherent in telehealth, it's the same thing applies on face-to-face consultations. Cyber risk is probably the most specific to telehealth, and that's where Priyanka is going to jump in.
Thanks, Yash. So although telemedicine brings with it the ease and the convenience of remote medical consultations, the new medium introduces new vulnerabilities to cyber risk. And I would say this is more common with your virtual platforms and consultations on those forums as opposed to telephonic consultations. So what happens is that hackers will exploit the weaknesses they find in these platforms to access data, corrupt data, and obviously that's not a desirable outcome. So we have seen this in a variety of ways. So for example, some platforms like the current one we're on allows for recording of the conversation. Health practitioners need to be very careful about which platforms they use and the security that is offered because of a vulnerability like this. An example of how a risk can manifest in this context is these recordings of these telehealth consultations contain health data that's obviously very, very sensitive to the patient, and obviously bearing in mind the doctor-patient relationship. And if the platform is not properly secured, hackers can access the platform, access the recordings, and in some cases can hold the practitioner at ransom. It's called a ransomware attack, where they basically hold the data, which would be the form of an audio recording. The practitioner can't access it until he, for example, pays over the demanded sum of money, or even Bitcoin, which we're seeing is far more common now. And until that payment is made, it is possible that the hackers might not release that data, which means if the health practitioner needed that data to diagnose the patient, to recommend treatment, and so on, he or she will not be able to do that. And one of the other risks is that if the practitioner chooses to not pay that sum demanded, hackers may release the data to the public, and this again creates confidentiality issues for the health practitioner. And obviously there are more obvious, less technical risks that are associated with telehealth. So for example, And this is something that Yash alluded to earlier regarding guidance released by the HPCSA, which had to do with, holding, when you're holding telephonic or virtual consultations, if these are done in a public place like Starbucks, there are other people who might overhear very sensitive conversation between the doctor and the patient. Or if during a video consultation, the doctor has on display other patients' records in the background that are visible, it compromises the confidentiality with those patients. But I'll hand it over back to Yash to deal with just mitigating risk, and I'll come in from a cyber risk perspective again at that point.
Okay, thanks, Priyanka. So how do the practitioners then mitigate these risks? The most important thing that I can say is record keeping, coupled with informed consent. Now, a patient must know and understand the reasons why the doctor or the dentist or whoever is engaging in these telehealth consultations. They must understand and they must accept it. And ideally, what should happen is that there should be an informed consent form, a written form, which is signed and retained by the doctor. But taking into account the current situation, that would probably be impractical in a lot of cases, unless it's planned telehealth. But even if that's the case, where you don't have these written forms, the doctor must still have the conversation with the patient and say, this is the reason why we're having these telehealth consultation. For example, we want to avoid you having to come in unnecessarily if we can deal with your issue remotely. These are the risks involved. This is what can and what cannot happen. And the doctor must write this down in their notes somewhere, even if the patient hasn't signed anything, and retain that as a form of their records. It's very important. Another tip is, if the consultation is recorded, the patient must know and agree to this recording, and then the doctor must bear in mind that if the consultation is recorded, then that actual recording of the consultation forms part of the medical records that doctors usually have to keep in their file. So, after the consult, they shouldn't just delete it or make sure or let it expire in the cloud somewhere after a few days. They must keep it as if it was a normal medical record. Other points, again, we say document, document, document. So document everything. Take a detailed history. Now, practitioners are often known for not taking the most detailed records, but if they're engaging in telehealth, they absolutely must go the extra mile and make sure that they document everything, from taking a detailed history. Their observations are important. So, for example, if there's been a cut in the transmission, if the line was unclear for a specific moment, the doctor should note that somewhere in their notes and say, at this point, there was a break in transmission, the patient came back, we discussed it, we agreed to carry on, things like that. Document the advice given, the follow-up, everything. But doctors must realize that if they have any concerns regarding telehealth, what they must do is defer the consultation either to a later date or refer to a face-to-face consultation. Now, good examples of when they should do this is when, for example, they're unable to identify the patient. So some person calls you up randomly, you've never dealt with them before, and they say, I need a prescription, I'm feeling sick. That's a clear red flag and a clear indicator to the practitioner that, I'm not comfortable with this. We need to refer this to a face-to-face consultation, either with somebody who's nearby yourself, or you can come consult with me at a later stage. Another example is, of course, if a physical exam is required, you can't do it via telehealth. If you have IT limitations, like you can't comply with all the specific regulations of the Allied Health Professions Council, etc., then you just simply say, let's do a face-to-face. And then Priyanka is going to come up again on cyber risk.
Thanks, Yash. So as you may be aware, the Protection of Personal Information Act, also known as POPI or POPIA, some people like to call it, it's not yet in force fully. It was expected that the president would bring the act into force on 1 April this year, but I suspect that because of all the kind of upheaval with the COVID-19 regulations and whatnot, this has been put on hold. But I think we can anticipate that it'll be promulgated soon. But once POPI does come into force, it will obviously apply to the processing of health data on top of the confidentiality and privacy obligations that health practitioners are already obliged to comply with. What we're looking at is that they need to ensure that how they access and use and process that health data is secure. So we find that many people are already complying with POPI as if it's already in force, and this is really for two reasons. Firstly, the regulator has been quite proactive, quite on the scene. She's been very vocal about companies' non-compliance with POPI where data breaches occur. So from a reputational perspective, people are complying with POPI. And then on a second note, POPI actually contains quite sensible obligations in place that if complied with, actually can mitigate your risk quite significantly. Because what it says is that you need to implement, technical and organizational measures to secure the data you process. So in the context of telehealth and consultations, you'd want to, as a health practitioner, you'd want to ensure that your platform that you're using is a reputable one in the event of any security issues. You want to ensure that your device has sufficient security installed on it to allow virus attacks, any attempts made by hackers to access your network. That they need to ensure that their passwords to their platform accounts are changed quite regularly, and should any electronic copies of scripts or health records be transmitted to patients, that this be done in a secure way. And I just want to point out that even though POPI isn't in force and there aren't any penalties for non-compliance, practitioners obviously do have obligations in respect of patient confidentiality, and the measures suggested obviously just enhance these obligations. I'll get into Zoom and whatever else later. I'll just let Yash speak to the next issues and wrap up.
Okay, thanks, Priyanka. So then, in a nutshell, IT guidance for HPCSA practitioners, at least, because you'll recall that the HPCSA wasn't too specific on the requirements in these latest guidelines and notices. Again, I must stress informed consent in writing. If you can't get it in writing, at least record it in writing that you've had this discussion and you've obtained informed consent. Secure internet access, prefer video consults over telephonic, but always, as I said before, the patient must know which platform you're going to use, and they must be happy with it and agree to it. So even if it's via WhatsApp, it mustn't be like the doctor's imposing this requirement on the patient, and the patient has no choice. There has to be this discussion and informed consent. And then the usual advice about keeping your devices secured. So if you have an iPhone, if you're consulting using an iPad, prefer a 6-digit passcode over a 4-digit one, which is more secure, and things like that, which you've all probably heard of before. And then the Allied Health Professions Council, as I said, have these guidelines which are quite detailed, and you can access them at that link. But you can also just go to their website, and it's on the landing page, so you don't even have to click anywhere. You just need to scroll a bit down, and you'll find these guidelines. What do these guidelines, what legal effect do these guidelines have? And I've alluded to it a bit earlier, where I said that the guidelines are not published under the law or as regulations. They're just put out by these councils. And our courts have had a look at this in the past, and you might have heard some legal experts who you chatted to who use the phrase often that guidelines are simply that, they're guidelines and nothing more. But what have our courts actually said about this? So the first example I've looked at is a case called Pandy versus Isaacs, which is in the Western Cape High Court. And that case involved the court having to look at the guidelines on informed consent, one of the booklets of the HPCSAs. And they said, and the court said, that the guidelines do not have the status of law and are merely part of the evidential material to be weighed in determining the standards reasonably to be observed by doctors. So that's probably where the usual refrain of the guidelines are merely guidelines comes from. Courts have said that these are just, they're not law and they're just evidence. However, in 1993, the Appellate Division, which is now a Supreme Court of Appeal, once said that a patient has the right to expect due compliance by the practitioner with his professional ethical standards. So conversely, what that court was saying was that a doctor has a legal duty to comply with the ethical standards. Now, those two are conflicting views. Recently, the Supreme Court of Appeal in 2019, in the case of Björkes versus Smith, dealt with informed consent, and in that case, there was it involved a complex surgical procedure or complex medical procedure, and the guidelines on informed consent by the HPCSA state that for complex procedures, practitioners should have written consent from the patient. In this case, there wasn't written consent, but what the court looked at was the other evidence that was handed in, and there was a motivation letter drafted by the doctor to the patient's medical aid. And in that motivation letter, the doctor had set out in detail the nature of the procedure that was to be undertaken. And the court said that, you know, considering that there was such a detailed motivation letter, this doctor must have had this conversation with the patient based on that, and therefore it was likely based on the evidence that informed consent was obtained. So in this case, also the strict requirement of having written informed consent wasn't met with, but given the evidence, the court accepted that there was informed consent. Now this raises the question, must then in law, legally speaking, if you go to court, must all the rules and guidelines that we've spoken about now be complied with? And this question was dealt with in the 2020 South African Law Journal by these two authors who have listed in the last bullet. And what they suggest is that given the conflicting views, you know, the one view saying that these guidelines are merely guidelines, and the other view saying that there is a legal duty imposed by these guidelines, what these authors suggest is that we must differentiate between substantive and formal norms. And I'm going to avoid being too academic and technical, but in a nutshell, what that means is they're saying, look at what the formal requirements are in the regulations and guidelines versus the substantive requirements. So formal requirements, for example, would be what the Allied Health Professions Council has said regarding a 3 megabit per second line and secure end-to-end encryption, video link, and all of that stuff. Those are very formal requirements. But what is the substance behind those requirements? What's the substantive norm that's trying to be achieved by these guidelines? That would probably be patient confidentiality, patient dignity, those kind of substantive norms. And those are what the authors argue should be complied with to the T. So even if a doctor has, for example, a 2 megabit line and consults, as long as it can be shown that they substantively complied with the requirements for privacy, etc., then the practitioner should be okay. But we must remember that regardless of what the courts say about these guidelines, failure to comply with them may nevertheless indicate unprofessional conduct, and the regulatory bodies may still take the practitioners to task. So if there's a complaint by a patient somewhere along the line where the patient says, no, but this doctor didn't use a video call, and the Allied Health Professionals Council receives this complaint, they could strictly speaking say, look, there's our policy decision, you didn't comply with it, now please answer to this. And that's always the possibility that could happen. And I said, however, here, because the HPCSA did, in one of its guidance notes that I mentioned earlier, say regarding complaints specifically, that they will consider the extraordinary circumstances in which practitioners are working and the heavy demands on them during this period. So they say that they're still going to process complaints during this period, but they're going to take into account what doctors are actually dealing with. So at the end of the day, as long as the practitioners can justify their actions reasonably, it seems like the council might accept their explanation should there be a complaint. Quickly, I see the time is running out, but I've mentioned this topic about informed consent quite a bit, and I just wanted to point us to the actual act or law. You know, that's the legislation that's been passed by Parliament regarding informed consent, and that's found in the National Health Act. And we must remember that the National Health Act applies to all healthcare providers, so that's anybody registered with the Allied Health Professions Council, the HPCSA, even the Nursing and Pharmacy and Dental Technicians Act. So it applies across the board. And this is what the law says regarding informed consent, Section 6. Every healthcare provider must inform a patient of 1, their health status, unless that would not be in their best interests, 2, the range of diagnostic procedures and treatment options generally available to them, 3, the benefits, risks, and costs associated with each option, and then lastly, the right to refuse and what the implications of refusing there are. So specifically here with regards to telehealth, I think the second point and the third point is crucial, as I mentioned earlier. So doctors should always give the patient the option and say, look, if we can't do this via remote consultation, we'll have to do face-to-face. These are the risks, and this is what, I don't have a secure internet line, for example. I don't have a video link up. I might be using a system that I would not be comfortable doing. The patient says, you know what, I don't care, go ahead. I accept those risks and I understand why you're telling me, and I can't see why it shouldn't proceed. And then lastly, I couldn't resist a good pun. I mentioned earlier that I saw the pun of eHealth going viral, so I thought, let me put one in myself, and I titled the slide "Food for Thought." And a lot of people might know about Prof. Tim Noakes. He's well known, he's a celebrity, and this has been published in the media, so I'm comfortable talking about it. In 2014, somebody tweeted him and said, is LCHF, that's low carb, high fat, eating okay for breastfeeding moms, worried about all the dairy and cauliflower equals wind for babies? And Prof. Noakes replied, baby doesn't eat the dairy and cauliflower, just very healthy, high fat breast milk. Key is to wean baby onto LCHF. And what happened after this was there was a complaint to the HPCSA, and this led to almost, I think, 5 years of professional conduct proceedings. And eventually, after I think 5 years, Tim Noakes was exonerated and came out on top after an appeal, etc. But the point I'm trying to make is, even this, a tweet can be construed to be telehealth. Not a good example of telehealth, but possibly telehealth. Now, from what I've reported, Tim Noakes was found not to be giving medical advice in this tweet because it couldn't be established that there was a patient-doctor relationship that was created by these tweets. But the point that, again, I try to make is that even a DM could be medical advice if not properly considered, which could lead to a complaint at the councils. And then lastly, post-COVID-19, what's the situation? And this is why I said, let's look at the context of where these new changes are coming from. It is COVID-19. And as I said, the regulators didn't one day wake up and say, wow, telehealth, brilliant idea, let's make it okay. They specifically said, the HPCSA specifically said it's only applicable during COVID-19 pandemic, and they will soon after the end of the pandemic, whenever that is, inform the practitioners when these updated views cease to apply. And the HPCSA has also specifically said that it's only for the period of the state of disaster or as otherwise directed. So it's anybody's guess as to what will happen, but based on previous conduct of the bodies or previous views of the bodies, it's probably safe to say that things might revert, although it might open doors to the bodies being a bit more accepting of telehealth going forward, but only time will tell. And yes, that's it.
Thank you so much, Yash and Priyanka. I think it was really interesting. And if now I could call on Fia, who's I2's head of medical malpractice.
Thanks, Justin, and thanks to Priyanka and Yash as well. I think that both Yash and Priyanka has spoken a lot about telemedicine and specifically what we are doing. One of the topics that Yash unfortunately didn't touch on is that we do provide cover to social workers. And the South African Council for Social Professions has actually issued guidelines under the ambit of e-social work. And we, if anybody does have any social workers on their portfolios, please contact us, because these guidelines are very interesting. And if you know what's happening in gender-based violence at the moment, specifically during COVID-19, it's important that we have our social workers on the ground and doing e-social work, specifically to help alleviate, of course, any child abuse and gender-based violence against women as well. Again, Health Professions Council has issued guidelines and directives, as well as the Allied Healthcare Professions Council. Our stance as I2 is that we are providing cover during COVID-19 for these professions as listed under the professions, specifically health professions and allied healthcare. Please contact us. We are going to be endorsing specific policies during this to ensure that cover is in place. In terms of other professions, we need to also just think beyond your general practitioners, your nursing professionals. You can think of yoga online, cycling, your online pharmacies. I had an interesting one. My son has braces, and instead of doing a normal consult, we had a virtual consult with his orthodontist, which was quite interesting because you'd think you'd need to be in front of your orthodontist. And we had to submit the files via a secure platform. The orthodontist then reviewed and had a consult with us, which was quite different to the norm in what we obviously used to. Also very important to know, and like Yash has said, consent has to be obtained. And whilst we are asking for informed consent in writing, it's not always possible. Make your notes. The rights of the patient has to be respected, as well as their rights to dignity, privacy, and confidentiality. I can't stress this enough, especially when you're dealing with elderly folk that might not understand platforms. They want to see you face to face. So it's important to please respect them and have dignity and privacy during that time as well. The best interest of the patient has to be at the foremost of your consult. If you cannot do a consult face to face, propose that they seek alternative assistance, such as going to a hospital or an emergency department. Under the Health Professions Council, you have individuals that are psychologists, and you might find that somebody is living alone during this period of time, doesn't have family members, and feels that they need to end their lives. A teleconsult with your psychologist is not going to help them. They're going to need immediate assistance. And it's important that the psychologist or even the counselor treating them recognizes this during the consult and transfers or immediately has help available for this individual. It's important to understand that always that you should make such recommendations on the patient records available, so that should a claim arise or a circumstance arise, that you have this available for you. Also, we live in a country, specifically South Africa, where technology is limited to those that can afford and have technology. There is inequalities that exist. Not everybody has access to Zoom or similarly Microsoft Teams. Some patients can't grasp the concept of technology. I find myself sometimes wondering how to zoom into meetings as well as Microsoft Teams. And it's difficult as a professional doctor as well to use those platforms, especially if they're the old school kind of doctors. Sometimes a diagnosis can't be made electronically and does require face-to-face interactions. Guidelines was issued by the NICD specifically in terms of how to handle your interactions face-to-face with your patients. These are available on their websites, and we do have them on record. So if you want me to share them with you, please drop me an email. I will share them with you, and as much as all the guidelines that's available that Yash has spoken to. I've taken time to download all these guidelines and booklets. I'm more than happy to share them with you at all times. In terms of our policy, please remember, again, the respect of security and protection of information is important. I know Yash has answered the question, as well as Priyanka, about Zoom. Prior to COVID-19, we didn't have any issues with Zoom or any other platform. We recommended that they used an end-to-end platform. I'm pleased to know or tell you guys that I will be issuing updated endorsements specifically for the HPCSA for recommendations to remove the end-to-end requirement of encryption. Whilst it's important for our practitioners to secure the information for their clients, we unfortunately understand that it's not always viable for them because many individuals won't be able to do that as well. Lastly, our policy does not cover cyber liability. It's important that you provide an option for your client to have cyber liability, and I'm sure Ryan will be chatting to you about the various options available under his product offering. We want to make sure that you as your brokers can tell your practitioners that they can be rest assured that we will be giving them all the cover during this pandemic, and we see them as the heroes in this, not the directors of companies, but those on the front lines fighting to save many lives. That's it from me. I think Ryan will take over quite briefly, and then we'll take questions.
Great, thanks everybody. I'd also like to just thank Yash and Priyanka for the insights that they shared. I think Priyanka touched on a lot of the cyber risks and things to consider from a cyber perspective. So what I do want to just sort of touch on, sorry, bear with me for a sec, is obviously doctors have been increasing the amount of digital data that they store and process, not just now during the COVID pandemic, but over the last couple of years as they've started to embrace platforms and electronic means to submit medical aid claims, etc. That has obviously been increased quite a lot now with having to do things like telemedicine, etc. But it has been a risk which has existed for quite some time. And this does bring a lot of the cyber risks to these doctors from the portals and platforms they're using. Sometimes the security around these, if they're using a third party, is out of their control. So they're very much exposed to the levels of security that those platforms are providing. And should there be a breach or a compromise of those, they could be the ones who are in the firing line. So they are still the custodians of the data which is entrusted by their patients to them, and in many cases would have very limited recourse, if any, against the third-party platform providers. So that is something that needs to be borne in mind. I'm just going to skip through some of these slides in the interest of time. So one of the big things that has come out from a lot of the studies done is that medical data is something which is often targeted by hackers because it tends to be very robust in the nature it has. So you've got a lot of information relating to a patient, things like their medical aid data as well, which can be used to commit fraud against the individual, against the medical aid company. And depending on how sensitive that medical history or medical data is, could be used to commit extortion against the doctor or in fact the patient as well. So it is a data type which has been targeted by hackers in the past. And if we look at the slide here, this is from the a study that was done where they found that healthcare records, so this was the Ponimon study where looking at South Africa as one of the countries they surveyed, and they did an actual analysis on what it cost to recover from a data compromise and broke that down into looking at the costs per different type of data type. And health records were by quite a long way the most costly and had the most damages attached to them. I think Fia touched on a little bit around, we are very aggressively looking at how we can assist the doctors who are really the heroes at the front line with cyber insurance cover to protect them should there be data that goes amiss. The normal cyber insurance policy does provide a lot of assistance and guidance on this, although we can tailor and tweak it if we need to a specific doctor's requirements. If we look at the normal sort of flow from an incident, you would have the emergency contact number that the doctor could contact if they had an actual or suspected incident. This would put them in contact with legal professionals who could guide them what they needed to do from a regulatory standpoint. So are there councils and bodies and regulators they need to notify? When do they need to notify them? How do they need to go about notifying them? And what data do they need to share? They would also have access to IT security professionals who would help them contain that incident, better understand it. So if they were compromised, how did the hackers get in? What data have they actually compromised? And how do we lock those hackers out so they can regain control of their environment? They'll also have the cover to communicate with those patients whose data has been affected and put in place remediation actions for them so that they won't suffer any further damages. That could be something like credit monitoring, it could be identity theft monitoring. Depending on the data, there's various options we can consider. If a doctor was to fall foul to a cyber extortion or a ransomware type incident, the policy is also going to kick in there to help them recover from that. So from looking to whether or not the extortion demand is legitimate, to if it is a ransomware incident, helping them to decrypt and regain access to that data if possible. And then if we move across into additional first-party coverages, we're also going to be able to assist them with loss of earnings to their practice while they're recovering from a cyber incident. And should there be any ensuing litigation down the road, we are going to pick up the defense and settlement of that litigation as well. So a cyber insurance policy very much caters to the needs that doctors have had in the past around the medical data that they were storing and processing or had access to. And we have obviously geared that up and are able to provide that with the requirement on telemedicine at the moment. I'm not going to spend too much time going through the core cyber modules. Maybe just a couple points to consider. Sorry, as you're working remotely that you could pass on to the doctors. One is to secure their Wi-Fi connections. So with a lot of default Wi-Fi connections we see, you find that there are standard passwords used on the routers. So the normal is admin as the username and then password, or admin as the password to that. Very simple to change. We have published an article on the I2 website with some steps through that. If there are questions, please contact us. We're happy to guide brokers as well as doctors and so forth through that process. Really important to make sure you're using secure passwords, and where possible, try and enable two-factor authentication, in particular for cloud-based platforms, which often provide that functionality. It just makes it that much harder for a hacker to break into, because they can't just guess your password. They now would have to get access to a one-time PIN as well. Patching. Always try to stay updated. Microsoft and different software platforms are very active in trying to address security weaknesses and releasing patches to address those on a relatively regular basis. So it's important to be wary of those, apply them when they come out, and reboot your devices on a regular basis. So your laptops, etc., so that you're applying those patches and keeping yourself as secure as you can from that perspective. Enable encryption wherever you can. So, if you are storing something onto a memory stick, or if you're using a laptop, encrypt those hard drives, encrypt that remote storage. It makes it that much harder to get access to that data if the device is stolen or compromised or lost, or whatever the case may be. Be super wary of non-trusted mails and websites. There's a lot of fraud going around, trying to get people to click on malicious websites or phishing emails. So if it seems too good to be true, ignore it. Try and stick to really known and trusted sources for information. And yeah, I think point 7 there, be vigilant. Think before you click. So we're living in extraordinary times, but that doesn't mean that we shouldn't maybe take a second and just make sure that we're wary of what we're clicking on and what we're actioning. Thank you.
Thank you so much, Ryan and Fia. So that brings us to the formal end of the presentation, but so if you do want to leave, you're welcome to leave, but very happy to take a few more questions. Yash, do you believe that the HPCSA requires practitioners to use end-to-end encrypted platforms, given the requirements of the telemedicine guidelines? That might be for Priyanka, but do practitioners need to use end-to-end encrypted platforms?
Look, that's a good question, and I know why it's come up, I think, because the original guidelines did mention something about face-to-face consultations. Now, as I said, the council hasn't been clear enough to say, as the Allied Health Professions Council has specifically said, it needs to be end-to-end and encrypted and video link. But I think going back to the context behind this, and why I think it's probably not necessary. Now, I can't say this with certainty and conviction. It might not be necessary, arguably, because the latest guideline that the council has put out has used the word telephonic. And in the original guidelines, I even did a word search. There's no reference to telephone on the original guidelines. The only reference to telephone on the original guidelines is the HPCSA's telephone number. So I think one could argue that based on the recent guidelines, it's not necessarily a requirement, but I would still, if I was a practitioner that wants to engage in telehealth in a regular course of things, not just in emergency situations, I would personally make sure that I use a platform that's end-to-end encrypted and that I'm comfortable with.
Great, thank you so much, Yash. We've got another question here from Dion Burrs. And he says, what about psychology, this critical discipline using telehealth platforms, as well as speech therapists, dietitians, social workers, nurses? What is your view on them using these telehealth platforms?
Yeah, so the guidelines, when they were amended, specifically, initially even, mentioned that telepsychology and telepsychiatry are allowed. And this was even before the HPCSA put out a subsequent guideline. So as far as I'm concerned, and from what the HPCSA said, it's acceptable during COVID-19.
Okay, great. And then we've got another question from Carmony. Sorry, I'm firing away here, but there are lots of good questions. So shouldn't the relaxing of scope be more specific relating to the duties pertaining to testing for COVID-19? If they are broad, doesn't this open regulation up to abuse, or is there an advantage to applying a broader approach?
Well, that's a great question again. And you know what it should be. Of course, it definitely should be. I would have loved it if the Minister of Health, for example, came out with regulations to say this is what can be and this is what can't be done. But we can just look at the example of other regulations where it comes to hot food, for example, which has nothing to do with this talk. But that caused so much confusion. And of course, ideally, I would like it to have been specific and said this is exactly what can be done and exactly what can't be done. And for now, all we'll have to do is try and interpret the latest notices as best we can. I have written to the council to ask them to specify. I haven't gotten a response yet. So.
Great. And then we have a question on Zoom. So certainly in our business, we've been talking about Zoom quite a lot. What are your views of practitioners using Zoom? Is it secure and safe? And does it make a difference if they're using the paid for sort of updated version of Zoom?
So I think I can take this question, Justin. So, I mean, Norton Rose Fulbright, we use Zoom for a number of our clients, but I think you need to, I think the paid for option allows you to disable all the features that create security risks. So for example, disabling meeting recordings if that creates a risk, or, you know, because it's saving it to the cloud, which is not always the most secure platform. To enforce meeting passwords as well, that can be a feature you can enable using the Zoom platform. Disabling chat cloud saving is another way to go about achieving security. Making sure your encryption settings are activated using Zoom. And just things like that. So I think explore the features available under the paid for versus the trial or the free option, and see which one gives you more control over the security of the platform. But Zoom, I think, is fine, provided.
I think that clarifies things for a lot of us in the insurance industry as well, where Zoom has been questioned. And we have another really good question from Christy Carr again. And she says, can a patient indicate that they understood that a certain platform has potential security issues, but they accept this risk and they want to go ahead and use that platform? I.e., can a patient consent trump the required imposed requirements on practitioners?
Well, yeah, well, so the last part of that question is the difficult one to answer, whether it can trump the requirements. But that's why I was harping on the whole informed consent thing from the get-go. If the patient says, look, you've told me you're uncomfortable using Zoom for X, Y, Z reasons, but I don't care, go ahead, I accept all of that, and I understand the risks, and I'm happy to proceed even with the knowledge of those risks. In law, you've technically met the requirement of informed consent, most likely. But then again, I go back to the regardless of what our courts say slide, which says that regardless of what's correct in law, the council might take a different view, and if there's a complaint that stems from that, they could still take you to task. So it's a difficult one to answer with certainty. That's all I can say. Yeah.
Great stuff. I'm going to take one more question, and then we're going to move on to Fia and Ryan, and then we'll maybe take a few more questions at the end. So we've got a really good question here from Sam, and Sam says, to what extent do you believe a doctor can be compelled to assist in screening of patients and exposing themselves to the virus? I believe that he or she could levy a limitation of rights. In terms of the Hippocratic Oath, they are obliged to state when they're not equipped to assist. So what is your view on doctors being forced into areas that they're not really equipped to deal with?
Okay, so remember, the council has said that they must take into consideration their experience and their ability to do things with reasonable skill and care. So I think a distinction must be drawn between what a doctor is uncomfortable with and what a doctor is incompetent with doing. In the latter instance, if the doctor is incompetent, then clearly that's cause to say, look, this is not something I'm competent doing. I need to refer you elsewhere. If it's something that a doctor is uncomfortable doing, particularly in COVID-19, for example, screening, that might not necessarily be a justification for refusing to do it. And we must also always bear in mind that the Constitution says that everybody has a right of access to healthcare. So they must be given that access. But a doctor is not compelled to always treat a patient regardless of the circumstances. They must bear in mind what they're skilled and can do relatively safely. So if they're incompetent, if for example, you can't ask a dentist to go and intubate a patient if a dentist is incompetent, has never been trained in that. Whereas if you ask a specialist who had gone through the undergrad training, had gone through his different rotations in trauma, etc., it might be uncomfortable because they haven't done it in a long time, but they've still been trained and they can still do it with relative safety. So in that situation, I think they should do it given the current COVID-19 situation.
Perfect. Thanks very much, guys.
However, the Allied Health Professions Council seemed to me to take more of a proactive stance. And what I would say to the insureds who are registered with those with that council is just make sure you follow those guidelines to the T, because they have really given specific guidelines. And that's the only way you're going to avoid a complaint that emanates directly from the council, at least. What patients end up complaining about down the line, I'm not even sure what the uptake of telehealth is at the moment. So haven't really seen complaints directed towards remote consultations, but HPCSA definitely stick to the T and make sure, even if you're putting it out there on your practice webpage that you're offering telehealth consults, at least say somewhere in the bottom that it's in compliance with the latest directives by the HPCSA, so it doesn't raise eyebrows with the council and then have them come knocking to ask you what's going on.
Thank you very much, Yash, and thank you, Vali, for the question. We have another question from Diane Kirk from Willis, and maybe Fia, if you could just give us your thoughts on this. And it's
sure, Justin.
But a question as well. So, should we be asking our insureds if they are providing services wide of their speciality during COVID times? And I think Yash has touched on this. But if you're a surgeon and you're suddenly asked to, be helping out with COVID, or you're a gynecologist and you're suddenly intubating and using a ventilator, should we be asking our insureds those sort of questions where they're practicing outside of the scope of their work and what they're specialized in?
Of course. I think it's most important, especially with your specialists, that we understand what they're undertaking. I mean, as we mentioned, we don't expect a dentist to go do brain surgery. And I think good risk management would be that we find out what the scope of practice is and what they are doing. Because I find that situations, a lot of our practitioners, specifically your specialists, they work in hospitals, and during the COVID, a lot of elective procedures hasn't been undertaken. So they're trying to assist where possible in government hospitals as well as private hospitals. So please, the more you disclose information, the better it is to underwrite as well at claim stage should something arise and there be issues at council as well.
Fia, one more question for you, and this is actually from me, but okay. I think you've done very well today, so well done. And I think you've shown to be an expert in your field. But maybe give our brokers one reason why they should come to I2 MedMal.
I think between our underwriters and our claims division, we have the best team in South Africa. Heads off to Vali and his team. I think I can't do my job without them. We have an excellent chief underwriting officer. We think out of the box, and we're definitely the expert leaders in our business.
Great. So to all of our brokers, there's one thing that I2 want to be famous for, and that is that we want to be experts in this field of medical malpractice. Where we're not there yet, we'll be humble and we'll work even harder to get better. So I'd like to say a big thank you to Yash and Priyanka from Norton Rose, and to Ryan and Fia from I2. It's an unbelievable time to be talking about medical malpractice and cyber cover in the same conversation. And I think it's a good indication of the world that we are living in. And there's one way to do that, and that's to partner and work with experts. And I don't think that I've seen a panel of experts like we've had today. So thank you very much to all of you that have listened. And thank you very much to our experts that have represented I2 here today.